Hello viewers, in the continuation of our previous lecture on the subject cyber law, today we will discuss cyber crime and preventive laws and appraisal. Cyber defamation, also known as internet defamation or online defamation, is defamation in the world of internet and its users. Cyber defamation is amongst one of the various cyber crimes that can take place. Unlike other form of defamation, cyber defamation can cause huge damage to a company in a very short span of time, owing to a worldwide accessibility of internet and its ever increasing number of users. Defamation laws vary from the country to country, and in the countries such as the Canada, Australia and the United States, it can vary from province to province and state to state. As with other Commonwealth countries, Canada also follows United Kingdom law on defamation issues. If a hacker breaks into a website and publishes a defamatory statement, the website host or ISP could be held liable. Recently, Australia's apex court gave a landmark judgment concerning internet defamation and the related issue of jurisdiction. In India, cyber defamation found in civil as well as in criminal proceedings against the accused. So, we will discuss briefly what are the defamation, cyber jurisdiction, laws and punishments, etc. The internet is a cheap, fast means of international communication of text, sound, image. In other words, an information resource without political or content boundaries, limited only by the extent to which the information providers are willing to disclose their materials and the fruits of their own writing and research. In the present day, websites displaying information of all kinds are proliferating. These sites are established and controlled by the internet service providers or sometimes by the company's information technology department. These sites can be accessed through suitable search engines which will trace and display information to suit the requirement of the searcher. However, not many of the companies are aware of the risk attached with the hosting of a website who would be held liable. For instance, if an employee clandestinely posts racist, sexist or defamatory allegations about a competitor on the company's official website, it is to be remembered that a number of features unique to the internet distinguish it from any other medium. These features have led to the current re-examination of existing law relating to defamation to allow for their possible evolution and ultimately their application in cyberspace. A key feature of the internet is its highly interactive nature. The ease with which users of the internet can access information and communicate with each other has engendered in its user a false sense of freedom in their communication. Accessibility is another feature of internet which distinguish it from traditional print or broadcast media. The relatively low cost of connecting to the internet and even of establishing one's own website means that the opportunity for defamation has increased exponentially. Now, on the internet, everyone can be a publisher and can be sued as a publisher. Another key feature of the internet is that users do not have to reveal their true identity. In order to send an email or post messages on bulletin boards, users are able to communicate and make such posting anonymously or under assumed names. This feature, coupled with the ability to access the internet in privacy and seclusion of one's own home or office, and the interactive responsive nature of communications on the internet has resulted in user being far less inhibited about the content of their messages, resulting in cyberspace becoming excessively prone to defamation. Defamation can be understood as the intentional infringement of another person's right to his good name. It is the wrongful and intentional publication of the words or behavior concerning another person which has the effect of injuring that person's status, good name, reputation in the society. Libel is the written defamation. Slander is the oral defamation. There is two kinds of defamation. One is libel, another one is slander. The primary difference is that in libel, damages are presumed, whereas in slander, actions, unless the slander fails into certain category called slander per se, the plaintiff must prove actual or quantifiable damages. A person's good name can only be damaged if maligning statements are made to someone other than that of person. That is, the defamatory statement must be disclosed to third person, thereby satisfying the requirement of publication. When determining whether or not the defamation has taken place, the only issue to consider is whether a person of a ordinary intelligence in society would believe that the words would indeed injure the person's reputation. Thus, the law of defamation places a heavy burden on the defendant. All that a plaintiff has to prove in a defamation action is the publication of defamatory matter. The onus then lies on the defendant to prove this innocence. Once again, the most people are unaware of this burden. In a sense, the law on defamation attempts to create a workable balance between two equally important human rights: the right to unimpaired reputation and the right to the freedom of expression. In a cyber society, both these interests are increasingly important. Protection of reputation is arguably even more important in a highly technological society, since one may not even encounter an individual or organization other than through the medium of internet. Then we will discuss which are the important elements of defamation. The very first one is the plaintiff must prove publication of defamatory statement. Then the plaintiff must prove that the defamation refers to plaintiff, and the plaintiff must prove the statement is defamatory. Upon proof of publication, the law makes several presumptions in favor of the plaintiff. The very first one is that the statement is false, that it was published with the malice, that in the case of libel or slander per se, the plaintiff has suffered damages. Defenses that can be raised against such a defamation actions are: the very first defense will be truth. The second one is fair comment. The defendant is allowed to comment on facts truly stated as long as the comment is fair and the defendant is not motivated by actual malice. Then the next defense is privilege. On certain occasions, the courts have held that policy and convenience requires that a person should be free from responsibility for the publication of defamatory words. These occasions constitute privileges. Privileges may be absolute, such as statements in the House of Commons or the courts. It may be qualified in that it may be lost if the publication is unnecessarily wide or made with malice. Then innocent dissemination. This last defense is potentially very important in cyber libel. If a defendant proves that his statement was true and in public interest, then his conduct is regarded as a lawful. In addition, if the defendant can show that he had no intention to defame the plaintiff, but then he could avoid the liability. This lecture seeks to throw light on the law relating to cyber defamation and to suggest a legal framework to handle such situation which is inevitable, especially in the light of present law in India. Then we will discuss cyber defamation, a socio-economic offence. Cyber law encompasses cyber crimes, electronic commerce and freedom of expression, intellectual property rights, jurisdiction issues and choice of law and privacy rights. Cyber crimes involve activities like credit card fraud, unauthorized access to computer system, child pornography, software piracy and cyber stalking. Freedom of expression includes defamation, obscenity issue and censorship. Jurisdiction issues focuses on who makes and enforces the rule governing cyberspace. The definition of what constitutes a crime in cyberspace is still being developed. In the past, the states and the federal government defined cybercrime activities to include the destruction or theft of computer data and programs. More recently, the definition has expanded to include activities such as forgery, illegal gambling, cyber stalking, cyber defamation, etc. There are several areas on the internet where there is real risk of liability for defamation. The fact that user is alone with his computer and distanced from other users create a sense of intimacy. There is no spoken telephonic conversation or dictated correspondence that would normally instill some caution. In addition, the notion that the internet is free for all, cyberspace where there are no limit or boundaries, results in a user's sense of social norms and propriety generally getting blurred. The web results in an instant global publication of information at a very low cost. Information which would not normally have been revealed prior to the drawing of internet can now be unearthed by practically any more. Intranets are intended to be exclusively used by a company. However, information from an intranet can be easily downloaded and forwarded by an email or otherwise to third parties. Information posted to a bulletin board can be accessed by anyone. This means that anyone can place defamatory allegation on the bulletin board. Email messages users generally tend to treat their correspondence as a kind of conversation rather than a written interaction. Users forget that emails are stored and can be retrieved as hard copies and their contents that cannot be disputed. One message can be circulated to literally hundreds of people. As a defamatory allegation needs only be disclosed to one person for publication to be proved, every time email is forwarded to another person, it is published again, an additional cause of action for defamation arises. The scope of every firm having a cyber presence to the liability for the defamation is global. Internet sites can be accessed in most countries throughout the world. Huge amount of data can be transmitted simultaneously to several different destinations, and email can be forwarded to an indefinite number of recipients without the original author having any control over the transmission. While a legal action based on defamation is usually aimed at stopping the defamatory allegation, the harm in most cases has already been done. Consequently, the most important relief claimed in the defamatory action is damages. The amount of damages granted will depend on the nature of defamation sought and the extent of publication. Furthermore, a defamation claim can be instituted in any jurisdiction in which a cause of action arises. In theory, then a potential defendant to a defamation suit could be sued in respect of a particular defamatory statement in a number of different countries with which it has no connection under any number of different law with which it is totally unfamiliar. Indeed, a potential plaintiff can choose to litigate in whichever country has the most favorable laws. Theoretically, every time a third party assesses a defamatory posting on the internet, publication has occurred. The global nature of internet also raises some interesting procedural questions for the libel lawyer. In traditional libel law, there are three different types of defamatory statement. The first is a statement that is a defamatory on its face and which is obviously a defamatory. The second is a statement which contains false innuendo. False innuendo is a defamatory statement that has an inferential meaning. Therefore, only persons with the necessary contextual knowledge appreciate the statement is defamatory. Since statements on the internet are published globally, their inferential meanings may vary depending on the geographic or cultural locations of the reader or the news group or the Usenet group involved. The third category is legal innuendo. While not defamatory on their face, these statements are defamatory when viewed together with extrinsic circumstances. Once again, contextual knowledge may render a statement defamatory in one jurisdiction but not in another. Cyber defamation need not necessarily be directed against an individual victim, but it could be harmful to the whole society. No doubt, at times it could be directed against an individual, but the criminal act is potentially capable of harming a large number of persons, and that is the principal object behind punishing it. In short, it is an offence which affects the health or material welfare of the community as a whole and not merely of the individual victim. Similarly, it is also an offence which affects the country's economy and not merely the wealth of an individual victim, since defamation of a corporate house could even adversely affect its share and value. Now, we will discuss significant aspect of social and economic offence. There are two significant aspects of social and economic offences. As the first one is the gravity of the harm caused to the society. The second one is the nature of the offence. The first one, as we discussed, the gravity of the harm is not easily apparent, but it is nevertheless undeniable. The nature of the offence is peculiar in the sense that they are planned and executed in secrecy by shrewd and dexterous persons with sophisticated means. The public welfare is gravely affected, but detection is unusually difficult. Cases of cyber defamation do not fit nearly in the accepted categories of crime. They represent harm of greater magnitude than the traditional crimes and of a nature different from them. Unlike traditional crimes, they are not in the shape of positive aggressions or invasions. They may not result in direct or immediate injury. Nevertheless, they create a danger which the law must seek to minimize. Hence, if legislation applicable to such offences as a matter of policies depart from the legislation applicable to the ordinary crimes in respect of the traditional requirement as to mens rea and other substantive matters as well as on the points of procedure, the departure would be justified. Then we will discuss that cyber defamation, what is the position in India. IPC on defamation, we can say Indian Penal Code. Chapter 21 of the Indian Penal Code exclusively talks about defamation. Section 499 prescribes the offence. Whoever by words either spoken or intended to be read or by sign or by visible representation makes or publish any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said except in the cases hereinafter expected to defame that person. Cyber defamation, also known as internet defamation or online defamation, is the defamation in the world of internet and its user. Cyber defamation is amongst one of the various cyber crimes that can take place. Cyber crimes are neither bound by time nor by national boundaries. There is a person sitting in one corner of the world can at any place easily cause damage to the person sitting in another corner of the world within a few minutes. Cyber defamation in a corporate world can take place in various forms. For example, a disgruntled employee of a company may post some defamatory remarks about the company on a popular blog site, or may send some slanderous email defaming the company or any of its important managerial personnel to the clients of the company across the globe. A competitor may divert the client and a customer of a company visiting the website of a company to any other website which may give some misleading information about the company. Unlike other united form of defamation, cyber defamation can cause huge damage to a company in a very short span of time, owing to a worldwide accessibility of internet and its ever increasing number of users. So, whoever by words either spoken or intended to be read, or by sign or by visible representation, makes or publishes any imputation concerning any person intending to harm, or knowing or having reason to believe that such imputation will harm the reputation of such person, is said to defame that person. So, in explanation we can say it amount to defamation to make an imputation concerning a company or an association or collection of a persons as such. Section 500 prescribe the punishment in such cases. Whoever defames another shall be punished with a simple imprisonment for a term which may extend to 2 years, or with fine, or with both. Then we will discuss employer's liability. A company can be held liable for the conduct of its employee if an employee during working hours emails a defamatory remarks about the competitor company to a colleague. The firm could be held liable for defamation even if the employee's actions were not authorized or expressly prohibited. For example, in a dispute which arose in United Kingdom between the Western Provident Association and Norwich Union, it was suggested that Norwich Union staff was spreading email rumors amongst their sales forces that WPA was more or less insolvent under the investigation by the Department of Trade and Industry. WPA sued Norwich Union, alleging that the latter was responsible for the communication made by its employee, even though the allegations were made without the instruction or knowledge of the management. The case was settled out of the court, but it's believed that Norwich Union paid approximately £500,000 to WPA in a settlement. Further, the offence of defamation as defined in IPC when extended to cyberspace may not achieve the desired result. However, the Australian judgment can be cited as a precedent, and that will have a persuasive value in India. Hence, if defamatory material is downloaded by someone in India, that will be enough cause or action even if the server of such sites are located outside the India. Now, we will discuss Cyber Defamation and Information Technology Act 2000. In India, cyber defamation founds in civil as well as in criminal proceeding against the accused. Some of the acts and rules that deals with cyber defamation are the Indian Penal Code 1960, the Information Technology Act 2000, the Code of Criminal Procedure, and the Indian Evidence Act. The Charging Act or the Prevention of Cybercrime in India is the Information Technology Act 2000. Section 66A of the Information Technology Act 2000 provides punishment for online defamation. Section 66A can be read as follows. Punishment for sending offensive messages through communication services, etc. Any person who sends by means of a computer resource or a communication device any information that is grossly offensive or has a menacing character, or any information which he knows to be false, but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, or ill will, persistently makes by making use of such computer resource as a communication device. Then the third one is any electronic mail or electronic mail message for the purpose of causing annoyance or inconvenience, or to deceive or to mislead the addressee or recipient about the origin of such messages, shall be punishable with the imprisonment for a term which may extend to 3 years or with the fine. For the purpose of this section, term electronic mail and electronic mail messages means a message or information created or transmitted or received on a computer, computer system, computer resource or communication device, including attachment in text, image, audio, video, aid and any other electronic record which may be transmitted with the message. Section 65A and Section 65B of Indian Evidence Act 1872 provides for the admissibility of electronic records as evidence. Some of the sections of the Indian Penal Code that deals with the cyber defamation at section 499, 500 and 503. In concluding remarks, we can say that the Indian IT Act also need to evolve with the rapidly changing technology environment that breeds new form of crimes and criminals. We are now beginning to see the new categories and varieties of cyber crimes which have not been addressed in the IT Act. This includes cyber stalking, cyber nuisance, cyber harassment, cyber defamation and the like. Though section 67 of the IT Act 2000 provide for the punishment to whoever transmits or publish or causes to be published or transmitted any material which is obscene in electronic form with imprisonment for a term which may extend to 2 years or with fine which may extend to 25,000 rupees on the first conviction, and in the event of second may extend to 5 years and also with fine which may extend to 50,000 rupees. It does not expressly talk about cyber defamation. The above provision chiefly aim at curbing the increasing number of child pornography cases and does not encompass other crimes which could have been expressly brought it within the ambit of such as cyber defamation. Thank you viewers for watching this program.